My name is Kent Hart. I am the Executive Director of the Utah Association of Criminal Defense Lawyers. I've also represented death row inmates. I've done so throughout my legal career over the past 20 years. Representing someone on death row is qualitatively different than any kind of case, civil or criminal. The stakes are so much higher. The media attention is glaring. The stakes are high for the prosecution, they're high for the defendant because it's life or death. And because it's a death case, the stakes are just as high for the defense. The pressure is intense. The number of documents that are produced are in the thousands, sometimes hundreds of thousands. So everything about the case is qualitatively different than any other kind of case. The process in a death penalty case is much more complicated than any other kind of case because life or death is an issue. So because we want to be sure that the person actually committed the crime and is deserving of death, we want to be sure that the sentence is appropriate. And the sentence is also irreversible if we execute someone. So we have to be sure that this person is properly convicted, not only of the crime itself, but also that the sentence imposed is actually legally appropriate and factually appropriate. So some of the things that we do to ensure that this sentence is correct is that we have at least 3 levels of review. There's one level through the state court. After a conviction, they appeal to the Utah Supreme Court. Once that is done, they can petition for a review in the United States Supreme Court. That is often reviewed or denied, but it's a possibility. Then the case will go back to the trial court where issues other than guilt or innocence are raised. Most commonly is the effectiveness of the trial attorney. It's a given that because someone got a death sentence, you're going to claim that the trial attorney did something wrong. So there will be what's called a collateral or a post-conviction proceeding in state court. That can go up to the Utah Supreme Court as well, and then higher up to the Utah Supreme Court. So that's the second round. Once that round is complete, you go to federal court, where the federal courts have an interest because federal constitutional rights are at issue. The right to life, the right to due process, the right to the effective assistance of counsel. So the federal courts want to make sure that this person was properly convicted and sentenced. So that then starts a third proceeding in the federal court that can then be appealed to the federal appellate courts, which then could go to the United States Supreme Court. Anywhere along that process, in any one of those 3 proceedings, the case could be remanded or sent back for a new trial. And so it's a very tricky process. You're setting yourself up for error, really, at any stage of the process. And so it can go back from square one, or it could go back to maybe round 2 in the trial court, or maybe in round 3 back to the trial court. There's just a number of permutations that can happen. In contrast to a death sentence, a life sentence doesn't involve this protracted litigation. There are several reasons for that. One is that for a death sentence, counsel is automatically appointed for both direct appeal and in the state post-conviction or collateral proceeding, the second round. So in a life case, counsel is not automatically appointed. Again, that goes to the seriousness of the penalty. Because we are so concerned that we get it right, we want to be sure this person has counsel appointed. And counsel will also be appointed in the third round in federal court. That is not the case in a life sentence. The right to counsel is only given to a person in a non-death case at the trial court and their direct appeal. So first of all, they don't have an attorney if they want to challenge it after the direct appeal. Another reason why a life sentence does not involve the protracted litigation is that when a person often is charged with a death case, they'll plead guilty to a life or a life without sentence. So when that happens, the plea agreement will eliminate many of the issues that can be raised in an appeal or in collateral proceedings. So there's nothing to appeal. Now a person can appeal even if there's nothing to appeal, but a court will easily dispose of that case, unlike a death penalty case where there will be dozens of issues raised. So there's just nothing to appeal when there's a life sentence. So for all practical purposes, the case is over. It ends. I have represented at least 10 people in Utah and Nevada who were given death sentences. The process is very similar in both states as it is in any other state. And again, as I mentioned earlier, this process is qualitatively different than any other kind of case. More attorneys are required. The state devotes more resources to these cases. Once the decision to impose death has been made, the state throws huge amounts of resources and people to try the case. In response, the defense tries to muster up all their resources. And because death is an irreversible decision, people are going to do everything they can on both sides to make sure that it's done correctly, but they're going to fight it. I mean, I have an ethical duty to my client who faces death to save that client's life. I mean, I hope that anybody would agree that my obligation as a lawyer is to my client. If you were in that client's shoes, whether it's a parking ticket, a burglary, or a death sentence, you want somebody who's going to fight for you. That's my obligation. And I hope that the public would realize that I should not be criticized for that. That's my job. If you're in that position, you want me on your side. And that's true wherever the case is. The death penalty process is inherently problematic because humans are involved in making the decisions about who is going to live and who is going to die. And I'm talking about prosecutors, I'm talking about judges, I'm talking about jurors, I'm talking about investigators, police officers. Government consists of people, human beings who are fallible. The system off the bat is fallible. The risk is that somebody who is charged with a death penalty case is possibly innocent, first of all, or possibly doesn't deserve to be punished. So let me just illustrate a few ways that the human element can come into it. One is the charging decision itself. Prosecutors often are elected. They are accountable to the public, which ordinarily I think is good, but politics play into this. So if a politician or a prosecutor who's elected wants to get publicity, they can. Death penalty cases are inherently just public interest stories. And so a prosecutor who seeks publicity will get publicity through a death penalty case. Another decision is what social science researchers call cognitive bias, which is just a fancy name for saying that people are human. And once we've made a decision, especially a serious decision that's under scrutiny by the public, like seeking death, the person making that decision is going to want to appear like they're right, and their decisions become more entrenched, and they won't give up that decision. Even if evidence comes along during the process of the case that may show that they have lesser culpability, or maybe they actually didn't do the crime, just to save face, we as human beings will say, well, no, this guy did it. I'm going to proceed with the case. I think those are just a couple of examples. Victims are another human element in this. Some victims, the families of victims, want justice. I think they're told that justice equals an execution. I think that's a false presentation. It's easy for me to say, I've never been a victim of a crime like that or a family member of a crime. But exacting revenge on somebody, I think as a human being, that doesn't seem to be right. Revenge or an eye for an eye has proven over the course of history, whether you view it in a religious context, a secular context, or a political one, is not the best policy. And in essence, that's what we're doing, is saying that we're going to serve justice by executing someone. I think we can do better than that. We as a society, whether it's morally or religiously or a matter of personal conviction, whatever it might be, I think we can do things better than saying we're going to kill someone. The process of obtaining a death sentence is also inherently flawed because there's an arbitrariness that's injected into the system, just as a matter of fact. One of it is that some prosecutors seek death more often than others. So depending on what county you live in can depend on whether you're charged with the death penalty. For example, Louisiana is famous, Cato Parish in Louisiana is famous for seeking the death penalty at a statistically higher rate than any other place in the country. So if you just happen to be involved with a crime in that parish in Louisiana, you're far more likely to be charged with a more serious offense there, and in particular a death penalty sentence, than in Salt Lake County, Utah. It's true for Utah. Salt Lake County doesn't seek the death penalty as often as maybe Weber County. I mean, I don't know if that's the case statistically, but it does depend on where you are and where you're charged. Race is another factor. We know that people who are African American are charged more frequently with a death penalty case than a white person, or even a Hispanic person. I'm not saying that prosecutors do this consciously. I don't think they are intending to apply the law arbitrarily, but we all have inherent biases that affect our decision making, and sometimes we aren't even aware of them. So this process of arbitrarily deciding whether this person or that person is deserving of a death sentence is something that just cannot be fixed. Until we as a society are able to eliminate all kinds of bias, whether it's inherent or subconscious, I don't think we can apply the death penalty fairly.